Forms of ownership section. Title can be held in severalty or as a concurrent estate. Severalty is sole or independent ownership by a person or entity. That means there is only one name on the deed. A concurrent estate describes the various ways in which property can be owned by more than one person at a given time. 3 types of concurrent estates are joint tenancy, tenancy in common, and community property. Tenancy in common is the most common type of ownership. Ownership is assumed to be a tenancy in common unless stated otherwise. A tenancy in common is a form of ownership of title to real estate by 2 or more persons. Although they have a unity of possession, they each have separate and distinct titles. In the event that one of the tenants in common dies, his or her title passes not to the other tenant in common, but to his or her estate or heirs. Joint tenancy is a form of ownership in which the tenants own a property equally. If one dies, the other automatically inherits the entire property. This is known as the right of survivorship. Thus, somebody cannot will a joint tenancy, and probate is not necessary under a joint tenancy. A person could not take a property as a joint tenant with a corporation. It would be taken as a tenant in common. If joint tenant dies owing debts, the surviving joint tenants are free of the unsecured debts. Joint tenants cannot be created by law, therefore the parties who wish to be joint tenants must make it clear in the conveyance document. A joint tenant has the right to sell, mortgage, or transfer the interest without the consent of the other joint tenants. To create joint tenancy, there has to be unity of time, title, interest, and possession. Joint tenancy would be terminated if any one of those 4 unities is destroyed. Therefore, a person who buys interest of a joint tenant would be a tenant in common with the other joint owners. For example, Stephen, Vivian, and Carol purchase a home in the hills, and they take the title as joint tenants. Stephen gets transferred to another state. He sells his property to David. Vivian and Carol are still joint tenants, and David is a tenant in common. Community property is property acquired by a husband and wife during marriage. Community property is owned by both regardless of whose name is on title. Separate property is sole ownership. Separate property is property acquired before marriage or property received by gift or inheritance. Separate property can be transferred without the non-owning spouse's consent or signature. A partition is a court action to divide ownership interest if the owners cannot reach an agreement. Partitions can be used by tenants in common or joint tenants to dissolve ownership interest. A trust is an arrangement where legal title is transferred from a trustor to a trustee. The trustee will hold title and manage the property for the benefit of another party called the beneficiary. A trust is very often used as an estate planning tool or to provide anonymity to a true owner of the property. There are several other items which are associated with a trust. A testamentary trust is created by a will and becomes effective upon the death of the testator. Many times, parents with minor children will set up a testamentary trust that will become effective should they both pass simultaneously. A living trust is also known as an inter vivos trust, or a trust that is to become effective during the life of the trustor. Please be aware of the difference between a living trust and a living will. A living will is a document that allows a person to refuse medical treatment. When a land trust is created, only real estate can be transferred into the trust. The trustee holds legal and equitable title to the real estate. The beneficiary retains the power to direct the trustee, manage the property, and draw income from the trust. This concludes the section on forms of ownership.